So part 2 of our look at the Dr. Ranson Tribunal and the concocted document saga, when a government department employed the Expol investigation company to look at the concerns raised about the disclosures, or for some, the non-disclosure of vital documents for the Dr. Ranson Tribunal to see. Once again, I do remind you, as the tribunal is still sitting, we must be incredibly careful what we can and can't say at this stage because it's due to the sub judice laws. As you know, the findings of the Expol report were put in the public domain following a successful FOI request, and that is really all we can examine today as proceedings go on. So why was the Expol report into the supposed concocted documents commissioned in the first place? Well, the tribunal expressed concern in its judgment when finding that Dr. Ranson had been unfairly dismissed after the making of protected disclosures about certain concocted documents. The claim by the Ranson team was that these documents had been produced by the Attorney General's Chamber acting for the Department of Health and Social Care as part of its obligation of disclosure of all relevant evidence. So the metadata demonstrating the originality of these documents suggested that they had been created shortly prior to the hearing, which, if true, could be presenting forged documents to a court and attempting to pervert the course of justice. Producing false documents in a court of law proceedings is a very serious criminal act, which, if proven, could lead to an immediate custodial sentence for the individuals concerned. So the context was hard-fought civil litigation where the tribunal found the DHSC, represented by the AG, had failed to make proper standard disclosures of documents which could have damaged its defence. To some, it might even be said that these hidden documents might even have demonstrated that the DHSC's legal defence was likely a bogus one. So the production of concocted documents moves us all now into a particularly sinister place because, if proven, it would put the honesty of the DHSC and the AG under intense scrutiny. So who commissioned and paid for the Expol report? Well, the tribunal did not commission or order the Expel report to be prepared. It had only asked for the metadata claims and the explanation for the supposed concocted documents to be made at a separate disclosure hearing. As such, the Expel investigation was never something that was necessarily within the legal process overseen by the tribunal. It was an exercise DHSC and AG chose to undertake for its own reasons using its own selected service provider. The DHSC, on advice from the AG, commissioned and dictated terms of reference for Expol, and surprising to many, the Expel report was published by the AG in response to an FOI request, even though the specific matter remains sub judice. And in other words, it remains an unresolved life issue being considered by the tribunal in active proceedings, which to some could seem extraordinary, especially given that Tynwald was prevented from debating the judgment on the Ranson case on advice from the AG, citing sub judice. It seems rather out of keeping for the Expel report to be published in this manner. Many other FOI requests, including my own relating to the Ranson case managed by Isle of Man government, are still declined by DHSC on the basis of legal privilege. So the publication of the Expel report in March 2023 sticks out as a real oddity. It could appear to some the DHSC and AG wanted to get their narrative out into the public domain that the Expel report found no evidence of criminal activity. More on that later. The terms of reference by DHSC and Expol have not been published, so we do not know precisely what they were mandated to do, or indeed, probably just as important, what limits or restrictions were placed on the investigation by the DHSC. However, we do know from the FOI response that the Expel report cost the DHSC and the taxpayer, therefore, a sum of over £68,000. So are Expel independent or partisan? Expel were engaged and paid for by DHSC and AG to investigate the supposed concocted documents. Of course, this is not the first time Expol have been engaged by DHSC in controversial circumstances. If you remember, they were appointed Expol to investigate the Abbotswood COVID outbreak. It would be normal practice for medical investigations into the quality of care providers would normally be referred to the Care Quality Commission investigators rather than to former police officers with no specific medical training or experience. Expol were appointed shortly after Catherine Magson, as CEO of DHSC, had decided to suspend the Abbotswood licence to operate, also making it unlawful for the operator to continue providing care to residents. At the time, there was intense public interest at what had occurred at Abbotswood. As a result of Catherine Magson's decision, Abbotswood was placed under the immediate direct control of the DHSC, and the staff who had been attempting to contain a COVID outbreak spreading among residents had to step aside in favour of the DHSC staff. The appointment of Expol in that case prevented all public scrutiny of the DHSC actions, and Expol's subsequent recommendations for a police review of potential offences led to no criminal charges being filed. This dragged out over many months, and a cynic might think Expol had been deployed by Catherine Magson as CEO of DHSC at a time of high public interest to kick that particular can down the road. Anyway, turning back to the Ranson case, Expol states in its introduction to the report that it is a company of corporate investigators staffed by former senior police detectives and was commissioned to carry out an independent investigation into the allegations. Interestingly, Expol placed a disclaimer on their work which said as follows: deny any liability whatsoever to any other party who may seek to use or rely on the whole or any part of this report for any purpose other than set out in the final terms of reference, dated 29th of June 2022, and the statement of work dated 18th of July 2022. Now, on the face of this could mean the tribunal are not entitled to rely on the whole or any part of this report. The contents of the Expel report was not presented in the normal manner to the tribunal proceedings by the DHSC with a signed witness statement, which should contain a statement of truth. So it could appear to some that the Expel report has little or no value to the tribunal. Dr. Ranson believes that Expel are partisan, but it'll be down to the tribunal to decide whether Expel are truly independent. And if the evidence uncovered is sufficient to allay the concerns about the concocted documents, well, certainly the Expel report leaves more new questions than it answers. And for many, it seems that it simply does not hang together as a comprehensive Bible to all the events surrounding the supposed concocted documents. But for £68,000, did the Expel report leave no stone unturned? Well, the Expel work was done in two parts. Expel dealt with the conventional phase, that was interviewing witnesses, some of whom were re-interviewed several times, analysis of evidence, and of course the statement taking. As Expel are not cyber experts, they engage another company called Ranson, who Expel say are highly experienced in the field of cyber security and digital forensic investigations. Ranson were responsible for the forensic and digital analysis and the recovery and the tracking of documents. The investigation focused upon the provenance of three documents known by their disclosure names as Z309, Z471 and Z475. Now we need to remember that there are two senior executives at DHSC who are very central to the events in question. Catherine Magson, the CEO of DHSC during the COVID period, and Karen Malone as her deputy CEO. And remember, after Miss Magson departed the post, Miss Malone was, sometime later, even though the tribunal was still sitting, she was appointed as permanent CEO of the DHSC by Health Minister Hooper, and later on she left that post after a period. Anyway, Expol point out that the need for the investigation was initially driven by the cross-examination of two witnesses by Dr. Ranson's legal team. Karen Malone on the 17th of January 2022, Catherine Magson on the 31st of January 2022. The tribunal criticised the evidence given by both Magson and Malone in its judgment on liability. And in examining Z309, Expol interviewed 10 witnesses. On Z471 and 475, they interviewed 7. The witnesses interviewed include people who no longer even work at DHSC or Manx Care. Notably, none of the witnesses interviewed, though, included Catherine Maxson or Karen Malone, whose evidence drove the investigation. To many, this may seem a remarkable admission by any standards, and it could beg the obvious question whether Expol were explicitly instructed under their terms from DHSC and AGs of reference not to interview Maxson or Malone. We have all heard that Maxson has refused to recognise the Isle of Man Tribunal's jurisdiction over her as a non-resident, so it might have been hard for DHSC to get her to cooperate with Expol. However, I understand that Miss Malone remains an island resident, so she would have been readily available if she wanted to. Expol were given access to numerous and other witnesses, some of whom no longer work for DHSC or Manx Care, but who submitted to giving formal statements. So some may ask, were Expol told not to touch the two central characters? Alternatively, if Expol decided not to seek interviews with Maxson and Malone by their own professional assessment, then what sort of ability do they have as detectives? Either way, to many, the omission of interviewing Maxson and Malone leaves a gaping hole in the credibility of this report. The converse to bear in mind, of course, is that the Expol investigation was a golden opportunity for both Maxson and Malone to supplement, clarify and correct their evidence previously given to the tribunal. A chance for them, in other words, to put the record straight and to show that they had nothing to hide. Was this omission a deliberate ploy of turning the so-called Nelson's blind eye so that Expol could report that no criminal activity was detected during the investigation? That's one of the questions. And when considered in its true context and its untimely publication, this statement is most likely the central purpose of the Expel report to many. It certainly seems to many that this was the narrative that the DHSC and AG would want the public to believe. Looking at the Expel report and the evidence it discusses, can we agree that no criminal activity was detected during the investigation? The short answer is no one can be sure about the truth of Expel's conclusions. It would be more satisfactory and the public possibly would be more assured if the tribunal referred this matter to the police for a proper investigation. However, that's a decision for the tribunal after it's considered the entire matter in light of events which have played out in the litigation before it. We simply won't know until a judgment is handed down whether the tribunal is now content that the evidence produced to it is okay. And remember, the only reason why we can even discuss this at all is because DHSC and the AG chose to publish the Expel report, place it in the public domain in response to an FOI request. On one level, it could just look like a crude attempt by the DHSC and AG to get their preferred narrative out to the public, in advance of course, any decision of the tribunal. Or it could be just incompetence or lack of sensitivity. Perhaps the DHSC and AG, once the tribunal decision is published later in the year, will clarify why they took this action. We could go further, but for now we have to tread very carefully around the context and remain measured and balanced in any commentary. But we will be back with more in part 3.